And so to jump in, Ahmed, why don't you tell us a little bit about the original guidance provided by USCIS back in October of 2023, and then we'll get into the details of the currently pending IIUSA lawsuit and the recent developments.
Yeah, and there's a ton of literature on this online, so I'm not going to get too deep into the nitty-gritty and play-by-play of how this all came about. But I think what's important for investors to know is historically, sustainment period has been one of the big lightning rods in the EB5 program, largely because investors who filed pre-RIA before 2022 had to keep their money invested really up until they filed their IA-29 petition. So through their 2-year conditional residency period. And for a lot of investors, this didn't have an effect, but for the majority of investors coming from backlog countries like India and China, where your conditional green card could take several years to be issued, this in many cases extended the timeline for them to also receive their money back from the project. In some cases, it even meant that your money, once it was returned from the first project that you invested in, now had to be reinvested into a second project in a process that we call redeployment. And we'll kind of illustrate that in a later slide to show how that works. But the RIA passed in 2022. It had some language that was, a little bit different than what we had seen before. And it basically said that, you were expected to remain invested for not less than 2 years, uh, period. And so USCIS clarified this language through a policy memorandum in October of 2023 that basically said, look, we're going to interpret this as if your funds go into the project and are used for job creating activities for at least 2 years, you have now met the sustainment period requirements and your funds can be returned to you. And what this essentially did was decouple your sustainment period, meaning how long your funds had to be invested, from the immigration timeline. So investors could now go into different projects and, especially investors from India and China, countries that are always kind of on the lookout for backlogs and retrogressions, and at least know that, okay, our funds are going to be returned to us in a timely manner, even if our immigration process gets delayed because of backlogs, retrogressions, et cetera. It also created some interesting scenarios and I think value propositions for investors who thought, okay, I've got concurrent filing if I'm in the US. What if I chose a project in a category that I knew was a little bit backlogged, but was giving me better terms, right? And so it created a lot of interesting scenarios for different investors, and I think a level playing field where a lot of projects suddenly became very attractive because of the financial terms they were offering, in addition to the immigration benefits that they offer through the EB5 program. And so this has been the rule. This has been the guidance that everyone is technically relying on up until today. And so what we've had since then is a lawsuit by IIUSA, which is a trade organization that represents a lot of the regional centers in the EB5 space. Um, and I think we can go to the next slide, Sam, and talk a little bit about that. Um, and without getting too much into the specifics of how this lawsuit came about and kind of what's happened along the way, the most recent update we've gotten happened last week, where a settlement proposal was basically submitted to the court. Basically, a joint status report filed with the court, letting the court know that there's an extension that has been requested to come to a final settlement agreement and laying out the terms of what the settlement might look like, both from IIUSA, in this case, the plaintiff, and from USCIS's perspective, in this case, the defendant. And in this, we got some really interesting kind of updates and language and some insight into how both of these parties were thinking about this lawsuit. I think most notably, IIUSA went on the record and essentially noted that they were not interested in disadvantaging investors who had relied on this guidance from October 2023 in filing their EB5 application, right? And so anyone who had previously filed and in fact will file before any settlement is agreed upon would be grandfathered in, and that minimum investment period of a fixed 2 years would apply to them. So this is kind of the biggest thing and biggest takeaway. It's not finalized yet. We're still expecting the final settlement to come out later this month, but it really, one, gives a lot of investors who have already invested a sigh of relief, knowing that most likely they're going to be grandfathered in and be subject to the rules that they relied upon when they made their investment. But it also opens a small window of opportunity over the next few weeks, really, before the end of March, before a settlement is finally reached, for new investors to come in and take advantage of that same rule, and basically, the full menu of options of short-term projects and longer-term projects and rural and high unemployment and all the other stuff, and really know that, okay, whatever the timeline of my investment is fixed, and not have to worry about redeployment or any of those other um, considerations that they normally have to do.
Yep.
Mike, you want to
Perfect.
add
Thanks,
a little bit more
Ahmed.
to
And
that?
yeah, and I would just say that at the surface, the reason for the lawsuit, there's lots of different opinions of why it was filed. There's a good point in that the way that the government came out with this 2 year period didn't follow the traditional path of the notice, the proper procedure to be able to make that rule, which is part of the reason for the challenge and is a good reason to try and make sure that the rule is done in the right way. Now, the reason that we are very much against the lawsuit, and we're publicly on record with that and wish that it was withdrawn or never filed, is primarily because it did create a huge amount of uncertainty for those investors that did rely on the official USCIS policy memo to make their investment. Now, assuming there's no changes to the positions of IIUSA and USCIS in whatever settlement is reached, it looks like that's valid and it will not cause any issues for those prior investors that went in. Of course, until the settlement is reached, anything can happen, but based on the position stated from both sides, it seems very likely that if you invested or you invest before the settlement, your sustainment period will be 2 years after you make your investment and will be decoupled from the immigration process of getting the conditional green card and waiting for the next 2 years as it used to be. So I'd say that's really good news from this. And I think the right approach from IIUSA and from the government is if an investor relied on it in good faith, they should be treated right. So no final resolution, but I think it shows that that's the right direction that we're heading in on that point.
Yep. And
Yeah.
so to add a couple of other just thoughts to that. So it obviously, first thing is a settlement has not been reached, right? So this is just a preliminary update, a joint status report filed by both parties laying out what the positions are and how things look, and requesting additional time to try to reach a settlement agreement that would ultimately be approved by the judge. So if a settlement agreement is reached, then that will be what will happen. If a settlement agreement is not reached, then eventually, likely in a few months, the judge would rule and would decide basically the outcome of this lawsuit. And so what I think is important here from a legal standpoint is that the government's position is that this 2-year period should just be the period of investment, which is what's been requested by IIUSA. So it seems like both parties are in agreement that anyone who's filed, should be able to rely on that. So it's pretty likely that will end up being the case. In terms of what would happen for investors who file after a settlement, there's a number of potential outcomes. So IIUSA has proposed a 5-year minimum period of investment. Another option could be a reversion back to the 2-year green card period. So it's unclear. It also could be a new rule that has to go through rulemaking as well. So there's a range of outcomes for what would happen or apply to investors who'd file after a settlement, but all of them are going to be worse than just a fixed 2-year period, right? So that's kind of the main point, is that if you file before a settlement and it actually is reached, you're going to be in a better position in terms of being eligible from a immigration perspective to get your capital back faster, 2 years only. Whereas if you file after, it's possible that it could be as long as 5 years. It could be you have to hold the green card for 2 years. And it's also possible that the exact duration that you need to hold it may still be unclear, right? It could be that the government has to go through rulemaking, and then whatever result of that is, that's what would apply to you. So it's a wide range of outcomes and potentially lack of clarity at the moment that there is a settlement agreement. So those are kind of the blocking and tackling details of what potential investors should be aware of. And it's also possible settlement could be a little bit longer than this month. There could be another extension. It just depends how close the parties are. In general, courts prefer to have the parties reach a settlement versus come in and pick a winning side. That usually results in a more efficient outcome. And so we'll just have to see over the next couple of months what plays out. Ahmed, do you want to walk us through these kind of 3 high-level points, just kind of summarize?
Yeah, and I think you and Mike just did a really great job of kind of helping investors understand the back end, how this mechanism has been kind of going on on the background, and what investors can kind of expect. And so yeah, I think what we're seeing, and again, I think I really want to stress the point that Sam just made, that look, a settlement is still yet to be finalized. The court has to ratify it. There's still some steps here, but I think what this proposal did, and this update did for a lot of investors, is show the direction that IIUSA is leaning. And I do want to commend the industry overall, investors, different channel partners overseas who have made their voices heard over the last month, as this settlement has kind of neared its conclusion, and really let the IIUSA know their position. And I know that we wrote a letter openly to IIUSA letting them know our position as well, and I think that's made a big difference. So what we're expecting to see, is that essentially investors who are able to fund and file, that means get an application into USCIS, and I would imagine receipted before any settlement is reached, may be grandfathered under the October 2023 interpretation, right? So the most likely outcome at this point seems like if you're able to kind of get your application in, or if you were already applied prior to this announcement or prior to this update, and your petition is right now pending, you are going to be adjudicated under the October 2023 guidance that USCIS issued, which would be,
how would that apply to investors who want to file before settlement, but maybe don't have all their capital available, want to do a partial filing? Like how would that work, and would they still capture that shorter duration benefit?
Yeah, that's a great question. And I think that's kind of the way that a lot of people should be looking at it, is if you are able to get your application in, and if one of the ways that you can do that is through a partial funding, that should still grandfather you, right? Well, the cutoff here is going to be receipt notices issued by USCIS before a certain date. And so if you're able to do a partial funding, you're able to work with a regional center that accepts partial funding arrangements for their projects, you're going to be able to kind of lock yourself in, and you don't have to create that whole liquidity of $800,000 right off the bat. So I've talked to a lot of investors over the last 3 or 4 days that have asked that exact question, like, hey, am I able to file my application somehow with less than 800,000? I know where my 800,000 is going to come from. I've got the documentation to show where that money will eventually come from. But right now, today, I only have liquid about 250K. Is that enough to get my application started? And the answer is it depends on the regional center, but at least with EB5AN, that's something that we can be flexible around and work with the investor to get their application filed, get their concurrent adjustment filed, even with less than the full $800,000. We do work, closely with the immigration attorney in that situation to confirm that everything is above board and they're not taking unnecessary immigration risks. But that to me is a great way to very quickly get your application in, especially if you're interested in a project with a shorter fund return timeline, and lock yourself into the October 2023 interpretation, most likely. And just a quick reminder that interpretation is your funds go into the project and are used for job creating activities for at least 2 years. that box is checked, and now you can receive the funds back, whether that's in 3 years, 4 years, 5 years, whatever. It's just a 2-year kind of flat period that your funds have to be used, and you'll now have met the sustainment period requirement.
Got it. All right, let's spend a minute talking about the sustainment period through rulemaking. What, if that's part of the settlement, what could that potentially look like?
Right. And this was something that was also mentioned in the settlement. The word expedited was used. No one really knows what that means just yet. But USCIS is definitely going to move forward with some kind of formal rulemaking to establish a clear new investment period. What that investment period would be is, it's really up for debate right now. Certainly the law still says 2 years. And so there's a very good chance that it ends up being a flat 2-year investment period anyways through formal rulemaking. I think IIUSA wanted to really establish this protocol that anytime USCIS wanted to have some kind of guidance that was, that had such a big effect, that they went through the proper channels and did normal notice and comment to get that rule instituted. And I think that's what's going to happen here. Could it be longer than 2 years? Yes, potentially there could be, a different number altogether. Maybe 5 years, that's a number that IIUSA has proposed previously. But what that is, we don't know yet. I don't want to conjecture just yet. All we know for now is, look, there is some guidance already in place. If you're able to get in before a certain date, it looks like that guidance is going to be what's applied to your case. What happens in the future is a little bit up in the air right now, and that uncertainty will last until we see a formal rule actually come into effect. And that's what that third part here is, right? At this point, it really is unclear what that rule will entail and what the exact time period will be. It will be nice to have a final rule in place that gives investors certainty in terms of how long their funds need to be deployed. And so the hope from our side, I think, is to see that rulemaking process go through very quickly. But at the time being, we don't know exactly what it's going to look like. The worst case in my eyes is still the prior rule, right? 2 years of conditional residency, your funds have to remain invested through that. And a lot of our rural projects and a lot of rural projects in general will allow investors to not worry about redeployment, even if that ends up being the case, even if it is the worst case scenario. They don't have to worry about redeployment if they're getting their green cards fast enough through priority processing, and the project is long enough to kind of stay sustained through their conditional residency period.
Gotcha. Okay. All right. So let's kind of visually walk through this. Mike, do you want to walk us through this chart?
Yeah, absolutely. So on the top half of this, so if you're an investor and you invest today under the current rules in the rule book, 2 years is all that you need to invest. So even if it takes you 3 years to even get your I-526E approval and you don't have your conditional green card for much longer, if you're in a backlog country and invest in a high unemployment deal, you could still be repaid from the investment at the end of the loan term, which could be, let's say, 3 or 4 years. The financial side of the investment is done and you can get your money back. This truly does decouple. The way that I like to explain it to some people is at the start of EB5, you're getting on 2 different trains at the same time, an immigration train and a financial investment train. The 2-year period would make it so that your financial train, if in 4 years the deal is successful and that's the time for loan repayment, you could be repaid if your money was invested for at least the 2 years of it and get your money back. Versus if you come in and there's a different sustainment process, which historically it was 2 years post getting the conditional green card, it directly ties the return of your capital to being approved for the 526E, having a green card available, which we know for high unemployment deals for backlog countries will be quite a long time for that to be available, and rural is already heading towards the backlog as well. And then you needed to sustain for 2 years. So even if the financial investment was ready to pay you back in, let's say, 4 years, it's very likely that you may not be eligible for repayment under the program. And instead, you're going into this redeployment cycle, that red area, where there's a lot less control of the investment, and you end up having to keep your money invested for a lot longer than you should need to for the immigration part in the deal that you invested in to create the jobs. So really, it's just right now there's certainty that whenever the deal pays back, as long as you've been invested for 2 years, you can get it back. And then in the event that in the future, they go back to a 2-year post-conditional green card or some other type of rule, that the period could be longer. So I just want to stress again that the settlement isn't signed, but seeing where both parties are coming from, and they've made the indication that if you invest now under the current rules, no one's trying to change the rules on you, which is a big step in the right direction from our perspective, I think gives a lot of comfort to that strategy.
Yep. And so kind of as a result of that new guidance, new information that we have, it kind of leads us to the conclusion that urban projects with a shorter repayment period, illustrated at the top of this chart, where funds are coming back, year 3, year 4, but that's well beyond the minimum 2-year sustainment period that investors, theoretically, who come in before this settlement, would be able to take advantage of. And so we believe that this is going to cause increased interest in some of these shorter term urban projects for the time being until a settlement is reached, just for this particular reason. But again, a settlement is not guaranteed, but that's kind of the best information that we have available that we can share.